State Senator George Borrello, in an exclusive interview with WNY News Now, discussed the outcome of a lawsuit filed in July of the previous year against Governor Kathy Hochul and the New York State Department of Health. The lawsuit specifically targeted Regulation 213, a contentious isolation and quarantine regulation.
Okay, so we are rolling now.
Okay.
Okay, so thank you very much for taking the time to talk with me, Mr. Borrello. Can you just start by giving the viewers just an overview of what all is going on with this case?
So, as you may be aware, in July of 2022, last year, we successfully sued Kathy Hochul, our governor, and the New York State Department of Health against the isolation and quarantine regulation, which is Regulation 213, and it was struck down. That regulation was a horrible, draconian misuse and abuse of power. But our lawsuit was based on the separation of powers. And the judge agreed with us. He said that this was clearly a violation of separation of powers because it is the legislative branch, not the executive branch, that makes laws. And this regulation was in fact essentially a copy and paste from a bill that never went anywhere, Assembly Bill 416, which got a lot of attention as a very draconian lockdown procedure that had been around for years. In fact, before the pandemic, it was been around since 2015. And Assembly Bill 416 never went anywhere. It never had matching legislation in the Senate. It never had a single co-sponsor, Democrat or Republican, and it never got into a committee agenda. So it was an orphan, truly. And yet, somehow, our governor felt that it was appropriate to take much of that legislation and turn it into regulation. So, again, Judge Plotz in the state Supreme Court ruled that it was a violation of separation of powers, but he also went on to further excoriate the governor and the Department of Health, that this lacked any due process. Just to summarize, what this regulation would do is it would allow any public health official to show up at your door without proof that you're sick or infected, without proof that you're a public health threat, and with force of police, remove you from your home. Literally, they could show up at your door, and whether it's you or your child or your elderly parents or grandparents, and say, I believe you've been exposed to any long list of diseases. By the way, not just highly infectious, contagious diseases. Some of the diseases on this list that the governor and the Department of Health could change with the stroke of a pen are not even communicable diseases, including things like botulism, toxic shock syndrome is on that list, even Lyme disease. These are serious diseases, but they are not communicable diseases that would create a public health threat for infection. So, with all that being said, clearly the state Supreme Court decision was very clear that this regulation was null and void. Of course, the governor and the attorney general have all of our money to work with as taxpayers, and they appealed that decision. They appealed it to the appellate division, which is the next step up. Fast forward now to September of this year, where the appellate division out of Rochester, the 4th division, did hear the case. We had oral arguments. Our wonderful, fabulous attorney, Bobby Ann Cox, who's been doing this all pro bono, no pay. She is just a true patriot and defender of the Constitution. She made a fabulous argument in front of that the 5-judge panel. And we just found out a couple weeks ago that the panel reversed the lower court decision. However, they did not address the merits of the case. What the 5-judge panel said was that we lacked standing as state legislators to bring this lawsuit. Very, very concerning for them to say that, because it's basically saying that we as state legislators do not have standing to sue the governor, the executive branch, for a breach of the separation of powers. They did not rule on the merits of the case.
And that is just incredibly concerning because, I mean, whenever the only legal recourse to such actions is, lawsuits, but they're saying you don't have any standing to bring those suits, it feels like there's not really any way to push back against executive overreach.
Yeah, and this decision does have tremendous ripple effect on cases. If the court is ruling that we do not have standing, this could set a precedent for so many others. It is a really attack on our First Amendment rights and our right to petition our government when we feel something is wrong. It is a very disconcerting decision, and it is a step, I think, towards totalitarian dictatorship right here in the United States, right here in New York State, by allowing a governor to have such sweeping authority without the oversight of the legislature. So very, very concerning. I don't care if you're a Republican, Democrat, liberal, conservative. You should be very concerned about this ruling and about this governor's willingness to want to have such sweeping authority that would be handed down to low-level bureaucrats, including local public health officials, that could have this power to pull you from your home without any proof at all that you are a threat, that you even are sick. And without any without any limits as to how long you could be held, where you could be held, and absolutely no process, no mechanism for you to get out of that isolation and quarantine. So as a result, while we are disappointed in this, we are planning to appeal this decision to the highest court in New York State, the Court of Appeals. And we are hopeful that they will take the case. Of course, they're not obligated to take that case. Just like the United States Supreme Court, they can choose whether or not they hear a case. So we will see. I'm hopeful that if they choose to hear it, that they will decide this on the merits of the case and not on some, I believe, invalid technicality that we don't have standing.
Mm-hmm. Yeah, and I mean, I think this is kind of building off of what you said, but one thing that detractors might say is, all of a sudden you're against public safety, but this isn't what that's about. This is making sure that the government is not overstepping its bounds.
Absolutely. First and foremost, let me also mention that there is a law that has been on the books for 70 years in New York State that gives the public health authorities, the Department of Health, the ability to address someone who they consider to be a threat to public health. But in that 70-year-old law, there are plenty of due process protections. First and foremost, the law requires that this person actually needs to be sick, and that the government has an obligation to prove that they are sick. They also have an obligation to prove that they are a public health threat, and they have to go before a judge to get a warrant before they can take someone and forcibly quarantine them against their will. So the ability to control the spread of disease, communicable disease, is already in place in New York State. This regulation goes well beyond that, into the realm of, again, totalitarian dictatorship type regulation. And that's so those that think, the government needs to have this power, look at what happened during the pandemic, look at Ebola, whatever. Those rules are already in place. There were laws passed by the New York State legislature and that are used by the Department of Health and have been used for years, because there have been situations where you've had outbreaks of disease and so forth. And there should be tools to deal with that in an emergency situation. But you need to follow due process. That is a basic fundamental right provided to us by the United States Constitution.
Exactly. And this is not a binary thing where it's either do nothing or do everything.
Yes.
I mean, there is a median point.
Yes, you're right. This is not a binary choice. And also, one of the things that really disappoints me is the mainstream media continues to parrot the governor's talking points and saying this is only about highly infectious diseases, and it's not. There is a list of diseases that are associated with this regulation, many of which are not communicable diseases. Yes, we want to be able to do what we can to control highly contagious diseases, but when you could use something like botulism, which is food poisoning, as an excuse to isolate someone, take them from their home, that should be very concerning to every New Yorker and every American.
So is there anything else that you want to say about this topic?
I think that people might not understand the ramifications of this, the ripple effect. I think it's important that people understand that in this case, if this sets a precedent for who can bring a lawsuit against the government, this could be very difficult for people to be able to stand up and push back and say, no, this is wrong. It is a step backwards in our basic constitutional freedoms and quite frankly, it is an attack on representative democracy.
Yes, well, I mean, thank you so much
Yeah.
for taking the time to talk about it, and I really hope that we get to see this play out further in court.
Yeah, I would just tell your viewers to please pay attention, to please understand that the seriousness of this, and to speak out. Contact the governor. Tell him you don't want Rule 213 to be reinstated, and that you do not want to give, particularly these low-level bureaucrats, the ability to have so much power.